Okay. What we're going to talk about today, we're going to talk a little bit about what is estate planning, what is guardianship, why is guardianship necessary, who we should choose as guardians, and how life insurance and retirement accounts can be handled when we're talking about minors, and also, of course, how minors can actually inherit. With regard to estate planning, it's a fairly simple process. It involves creating of documents for the necessity of how you're going to leave your assets at your death, as well as how do you cover incapacity in the event that somebody becomes disabled, or even if you're out of town, unavailable, who's going to handle things for you. Asset protection, which we also handle here, is part of estate planning. It's an integrated plan. How you own things, how you title things so that not only do they avoid having to go through the court for probate, but also how can they be owned so that they're creditor protected. So estate planning can involve, court involvement would be probate, which is a process we can talk about. Essentially, the court has to handle any assets that are held in the person's individual name at their death. Anything else can be handled without probate if there's a designated beneficiary or if there's a joint owner. But when we talk about the court involvement today, we'll talk about it a lot with regard to guardianship, which in some essences is almost like probate during a person's life. If you want to do your estate planning, I highly recommend you don't do it yourself. I've seen many people do it themselves, fill in forms. Rarely does it get done correctly, and very often it's actually more costly than never having done anything in the first place. So it's very important to have an attorney handle that for you. You can keep things simple. You can make things complex. How much money you have is not always the determination of whether your estate plan can be simple. Sometimes very wealthy people can do fairly simple estate planning. A lot of it depends on who you want to inherit and what types of assets you have. And what's really important is you always want to figure out where do minors fit into this, or where do future children fit in. I've had many clients who've come to me. They did their will, they did simple wills when they only had one child, and then all of a sudden now they have two more. Do they really need to do new documents? Usually they think they do, but if a document is properly constructed, it's not always necessary to redo it. It should be reviewed, but it's not always necessary to re-sign. With regard to Anna Nicole Smith, she's a really good example. She did a very interesting will where she actually precluded future children from inheriting, which is extremely strange. Usually you would put in, you would name your descendants, which would include any future children. She did not, and then there was a whole big legal battle because when she died, her son had just died, and he was a named beneficiary, and she had just had a daughter, so there was a whole big legal battle. Ultimately, the proper result came out, and that daughter did receive her assets, but it was extremely strange the way it was done. I don't know what the attorney was thinking. I'm assuming she used an attorney to actually draft that up, but it was not done properly, so it's extremely important how documents are drafted. The focus of today is about minors and how minors can inherit anything and how they can own assets. Generally, minors are restricted as to how they can own anything. So you may end up with a situation where there's guardianship. Now, guardianship is where a minor is entitled to an asset, one or more assets, and in order for that minor to get that asset or any benefit of it, the court requires somebody to come in and become a guardian of that child. Now, it's not only for assets. Guardianship can be for custody of the child as well. We're going to concentrate mostly on the monetary aspect today. But let's just go into the difference between custodial guardianship and money guardianship. So there's the guardian of the person, whoever is going to have physical custody and care of a minor child, someone who's under 18. And guardian of the property is where the person is named to handle any money or investments or property that a minor would be entitled to. Depending on what state you're in, there are qualifications for a guardian. The first hurdle you have to get through is who under the law can actually be your child's guardian. In the state of Florida, where I do my practice, Florida restricts the guardians to being either Florida residents or an adult relative, whether by marriage or blood, where in the world. So I can have my aunt who lives in Wisconsin be a guardian, but I can't have my best friend who lives in New York because she is not a relative and she does not live in the state of Florida. So that's the first issue you have to look at, is will a person qualify on that part? Then if the person has any sort of criminal history, convictions, or is generally just not suitable for a guardian or doesn't have the mental capacity, then they too would be unable to be a guardian. So it's extremely important to make sure that you have covered all aspects. You can't just say, okay, I'd like somebody to be a guardian, because if you make that very important decision and then it comes to the court and the court says, well, this person is not going to qualify, well, then you're in a bit of a problem. Who's going to handle your children's money and who's actually going to, be their substitute parent, so to speak. So it's important that you essentially pre-qualify your guardians. And of course, you probably should tell them in advance that you've chosen them, because nobody really wants to be surprised at that. The guardians themselves have, depending on whether they're guardian of the person or guardian of the property, and the same person can do both, have different responsibilities. Guardian of the person, if they're appointed by the court in that role, has to account to the court each year and essentially do a report. And that report tells the court, where does the child live, where do they go to school, their educational situation, their social situation. It's essentially a form that you have to fill out, but there are things that the court just wants to know in order to make sure that the child is being taken care of. For guardian of the property, it's actually more of an accounting that you have to show what income came in through the guardianship assets, what money went out, what it was for. You have to look at what's the bottom line at the end of the year. You can actually have the guardian petition the court to get money either on a regular basis or on a one-time basis for certain things for the child. The key with this, though, is it's extremely expensive. Every time you need to get something from the court, it costs money and it takes a lot of time. So very often it's necessary to have a guardianship, but what we're going to talk about a lot today is how do we reduce the need for this. And then finally, whenever you name guardians in your will, it's very important to name a backup guardian, because what if your guardian who you named is unable to perform? You want to make sure that you've named the backup so that you're getting to make the decision who gets to be backup, and it doesn't just get thrown into the mix and you end up with some relative that you really didn't want to be taking care of your children after your death. One other thing I wanted to mention on guardian of the property, that doesn't have to wait until you're gone. If somebody actually leaves your children money in a will, or your child ends up with some sort of asset, you would go into the court and actually become your child's guardian of the property. You can qualify, of course, we would hope, but you're going to have to pay for an attorney, and it's not so cheap to get it filed with the court, to get yourself appointed. Every year you've got to do an accounting, and anytime you want to use any of that money for your child, you're going to have to actually go through the court. So why is it necessary to plan for the guardianship? For one thing, you never want there to be any sort of fight over your children if you pass away. What happens if one family wants the children and then the other family wants the children, and then they're going to have a big legal battle over it? It would be a lot easier if you had predetermined and spoken to everybody and said, this is what we want, this is what we think is in the best interest of our children. You also don't want to have any sort of gap in time. God forbid you pass away. If you don't have any named, nobody knows who's supposed to take care of your children. So, where are the children going to live? They're already going to go through major emotional upheaval, and now they're in limbo. Who's going to take care of them? Where are they going to live? Where are they going to go to school? Or do they get to keep the house? There's a lot that's involved. So if you don't make the plan, you're potentially putting your children in a very bad position, and you're putting in a situation where people may fight over your children, or God forbid nobody actually wants them because you didn't make a plan. So it's very important for you to plan for this. One thing that seems to be happening a lot lately in my practice is I have a lot of clients who have children either from a prior marriage or have children outside of the marriage, from a prior relationship. In that situation, the surviving parent is going to have physical custody of the children. That's not really anything you can do anything about. But what you can do if you properly plan in your will and your trust is to make sure that that ex does not have control over the child's money that you're leaving the child. And I've been doing that a lot lately because it makes a lot of sense. If the relationship isn't a good relationship, you don't want that person having access to the kid's money. You want to protect it so that the kid can use the money for what they need it for. So you don't ever want that wrong person to control your money. So it's important to actually write that in there and exclude that person from having any sort of control. And the only way you're going to get around that, because that parent would have the priority under the statute, is for you to actually write out, I want this person to be guardian of the property. If this person can't do it, I want this person to be guardian of the property, and to actually list as many successors as you can come up with, because you don't really want it to ever come to a point where there's no one named. And finally, what happens, it's not just in your will when you die, when a guardian might need to be appointed. What happens if you become incapacitated and you can no longer parent? Then it's important to know who you would have chosen, because a guardian might need to be appointed for your child in that situation. So who should you choose as guardians? We went into this a little bit before. In Florida, again, you can only choose residents or a relative. Person can't have any sort of felony on their record. You might want to consider a sibling if they're over 18, but on practice, say my 19-year-old could physically be a guardian, would qualify, but they're in college. Is that really something you want to do, is make them a guardian of a younger sibling? It just doesn't seem like a really good idea for either child. Also, are they likely to be able to handle money for the younger child? Not so much. So it's not really a great idea in most circumstances. You could consider what we talked about before, is separating out the guardian of the person and guardian of the property, which means you can have somebody who would do a great job taking care of your child and having physical custody of them, but somebody else who's going to handle the money. I know I actually have considered this with my personal life, where I think there's somebody who'd be really great to be my child's guardian and my child could live with them, but money is not really a good situation for them, so you wouldn't want to put them in a position where they'd be in charge of property. You want, benefits and detriments to the guardian's family. So what do I mean by that? Suppose you leave a lot of money for your children in life insurance and in other assets. So your children are going to be well taken care of. But if you put them in a family situation, whether it's with a relative or a friend who doesn't have much money, your kids would be able to afford to go to summer camp. They'd be able to afford a nice car, lots of nice clothing. And then the guardian's children wouldn't. So it becomes kind of a difficult situation. And you want to consider that, especially if you're going to put your kids with family friends. So sometimes what we'll do is we'll put in provisions that say that if my children are going to go to summer camp, then the guardianship can pay for the guardian's children to go to summer camp and things of that nature. Because you want to kind of equalize, you want your children to be able to fit in, and you don't want them to be resented. So you can do that. And the guardian can take a fee for their job as guardian, so that's also a decent way to to pay the guardian back for the role that they're playing, which is not even something you can really quantify. So yeah, you want to leave your estate very well funded. Life insurance is a great way to do it, so that the guardian's family should never have to feel any sort of pressure because now they've added children to their home. It doesn't always happen, but that's certainly the proper thing for you to do as a parent, is to make sure you've left your children funded so it'll never be an imposition, at least financially, on the guardian and the guardian's family. Life insurance. So most people have life insurance, especially when they have young children. And the reason they have life insurance, there's a couple of reasons you might have life insurance. One reason is that you have a very large estate and you want to use it for estate tax purposes, because if the government is going to take your money for estate taxes, it's good to have life insurance to be able to pay that tax. There's ways to own your life insurance so that it's not part of your taxable estate, but that's the subject for another webinar. So life insurance is a great way to fund your children's lives, education, and future. So it's something you should definitely look into. There's lots of different types of life insurances. I'm not here to sell you anything, but it's something you should definitely consider. You never want to put your children as beneficiaries directly. I just had a client come in the other day. He has, I don't know, $3-4 million of insurance in his one policy for each child, and every one of them is a minor. And I just looked at him and I said, not a good idea. Reason being, $1 million policy, this guy dies, the kid's a minor, and the kid can't get the money. So now we have to have a guardian of the property appointed. The money has to go through this guardianship. It has to sit there. Investments, the courts have been a little more lenient on what types of investments you could do. It used to be it would literally have to sit in a bank account earning nothing. But now you can petition the court, again, that costs money, to get some proper investments for the child. And then it gets monitored each year, all well and good. And then when the child turns 18, they probably haven't even graduated from high school yet, they can go to the court, terminate the guardianship, and take $1 million and whatever it's earned. Terrible idea. No 18-year-old needs to have $1 million. So there are much better ways to handle this. At the very minimum, most life insurance companies have something called a trust for minors, that they'll let it be held until the kid's 21. Still not your best choice. I would sooner see it as part of a trust, so that the benefit goes to the trust and the money can be handled by a trustee and used for the children's benefit without actually paying it to the children. The key with any sort of money going to kids is have it last for the longest period of time, but never have it where a child is your beneficiary directly. Another thing a lot of people overlook, and it does affect the kids, is when you don't insure your non-working spouse. So if your wife's at home, she's taking care of the kids, we don't really think about what that really means. That means if something should happen to her, you've got to hire a lot of people to substitute for that job, or you're taking time off to do it yourself. So that actually can be extremely costly. So don't forget to insure that spouse, because if, God forbid, they die, you want something coming in to compensate for that time and for the extra assistance that you're going to need. Another idea, and I do this with my children, is do a life insurance policy on your kids. It's a little morbid, but it's extremely cheap. It's a great way to, depending on what type of policy you have, it's a great way to build funds to pay for college. And then when they become of age, they can actually transfer the policy into their own name, and they've already got life insurance. So if for whatever reason they're not insurable, they've already got a policy in place. So it's a good thing for people to do. A lot of people will do it for grandchildren, but you do want to get a good policy. So, don't just answer the ones that come in the mail and those flyers. Talk to your insurance agent and get a proper policy. A lot of wealth from it when somebody dies comes from retirement. So the question is, I know that, I'm an adult, and if something happened to one of my parents and I was the beneficiary of their retirement account, then I would get that account and I would have a couple of options as to how to take the money after they died. I could do it as a lump sum. I can do it as an inherited IRA. I think I have about 5 years. I can take it over that one. There's different options, but I have every one of those options, and we don't have to worry about certain implications that you would have to worry about if you have minors. For instance, there are certain tax consequences when a minor is a beneficiary. So I'm not even going to go into all the little nitty-gritty of it today, but you need to make sure that you certainly, talk to your CPA about this before you make a minor a beneficiary of any retirement account. But you have the same issue with a minor as a beneficiary as you would with anything else. If they're required to take a minimum distribution every year, which is what happens when you're the beneficiary of an IRA or a retirement account, then, if they're a minor, they can't get it. So it means you got to have the guardian, and the guardian has to handle it as the beneficiary. You also can have a trust be the beneficiary. That's one way of handling it. And again, there are potential tax consequences, so you want to make sure to discuss it with your CPA, discuss it with your estate planning attorney to make sure that it's being handled in the best possible way in order to maximize all benefits to the child. Because there are actually a lot of benefits to having a minor, or at least somebody young, as a beneficiary of retirement, because you can stretch it out over a very long time, potentially tax deferred. So, you should talk to your financial planner about that as well. You can use the retirement assets to help with your children's, life expenses. Life insurance is definitely a much better way to do that because it's going to be lump sum versus retirement, which is doled out, over whatever the requirement minimum distribution is. So now we've talked about the different types of things that minors can get. Now the question is, what happens when they get it? We know minors should not inherit anything directly. We talked about that because if they do, they've got to have the whole guardianship set up. It's very expensive and it's very time consuming, and then at 18 they get it, which is really not a good choice. A couple of things that you can do. Number one, in your last will and testament, you can create a trust and say any money or property that would pass to a minor would instead go into this trust, the provisions of which are part of your will, and then the trustee is in charge. This trust can go on for a very long time and can handle any of your children's needs, and there's a lot of different options that you have, whether they get it at a certain age, whether it continues, through the lives of your grandchildren. You have a lot of flexibility here. So that's one option. An option that's extremely popular in Florida is instead of having that trust under your will, it's to create something called a revocable living trust, where you create it during your life. You transfer your assets, you have the benefit during your life, and then at your death, it's already owned by the trust. There's no probate involved, and your successor trustee takes over where you left off and handles the money again with whatever provisions you put in. Outright gifts to the kids, or just handles the money and takes care of them. A lot of flexibility you have with that. You have to just consult with your estate planning attorney. Another option, usually for smaller amounts, and if you don't really expect that you want the money to continue past age 21, is to have the money in what's called an UTMA, Uniform Transfers to Minors account. In Florida, we call it a FUTMA, the F for Florida. What happens is that's where your child has a bank account and you're the custodian. Most people probably already have those for their kids, but you can really extend that. You can own stocks. You can own interest in limited liability companies, limited partnerships. There's a lot of flexibility that you can have with that, where the parent or grandparent, somebody is custodian, can handle and sign anything. But again, when the child turns 21, it reverts back to the child. So it's definitely an option. I think it's at a very minimum what should be in every will, simple or not, that is an option where money to a child can be paid out that way so that you can avoid a guardianship. Okay, another thing we should definitely touch upon today is, well, what happens if your minor child has a disability? The autism rate has gone up radically. What happens if your child is not going to be able to handle money? You can handle this the same way you can handle, minors, and you might want to consider a special needs trust. Now, there's a lot of nuances to this. There's another webinar we did that goes into great detail on this. So you have to be extremely careful. You have to hire somebody who knows what they're doing in this arena, because there's a lot of special rules that apply, and if it's not done correctly, it doesn't work and can be extremely problematic. But the idea is if your child would be, or any beneficiary would be entitled to any sort of government benefits or is already receiving government benefits, then you don't want to have them lose those benefits by getting any sort of inheritance. So this trust lets them have the government benefits as well as benefit from the trust to a certain degree. So again, don't do it on your own. Don't even just go to a regular estate planning attorney. You want to make sure that the estate planning attorney that you use is fully familiar with special needs trusts. That's